Labor Law of Cambodia, 1997, Hours of Work. Section 2 Hours of Work, Daily and Weekly Hours, Article 137, in all establishments of any nature, whether they provide vocational training, or they are of a charitable nature or liberal profession, the number of hours worked by workers of either sex cannot exceed 8 hours per day, or 48 hours per week. Article 138, the work schedule is set by each enterprise for different jobs based on the nature of their activities and organization of work. When the work schedule consists of split shifts, the enterprise's management can normally set up only 2 shifts, one in the morning and the other in the afternoon. Article 139, if workers are required to work overtime for exceptional and urgent jobs, the overtime hours shall be paid at a rate of 50% higher than normal hours. If the overtime hours are worked at night or during weekly time off, the rate of increase shall be 100%. Article 140, the Ministry in charge of Labor can issue a PRACAS, ministerial order, authorizing an extension of the daily hours in order to make up for hours lost following mass interruptions in the work or a general slowdown from either accidental causes or acts of God, notably bad weather or because of holidays, local festivals, or other local events, in the following cases. A. Marking up for lost hours will not be authorized for more than 30 days per year and will be implemented within 15 days after the return to work. For agricultural enterprises this period is extended to 1 month. B. The extension of the daily working hours cannot exceed 1 hour. C. Hours of work cannot exceed 10 hours per day. Article 141, PRACAS issued by the Ministry in charge of Labor shall determine as follows. 1. The allocation of working hours within the 48-hour working week in order to allow for a break on Saturday afternoon or any other equivalent approach, on the condition that the extra hours do not exceed 1 hour per day of the regular schedule. 2. The allocation of working hours within a period of time other than the week, on the condition that the average length of working time calculated by the number of weeks does not surpass 48 hours per week, that the daily hours do not surpass 10 hours, and that the extra hours do not exceed 1 hour per day. 3. Permanent special dispensations that can be allowed for preparatory or supplementary work that must be performed outside of the limit set for general work of the establishment, or for certain categories of workers whose work is essentially intermittent. 4. Temporary special dispensations are allowed in favor of seasonal businesses and industries and certain enterprises in the following cases. A. For serious or imminent accidents, for acts of God, or for urgent work to be performed on machines or equipment, but only to the extent that this avoids a serious disruption to the normal operations of the enterprise. B. To prevent the loss of perishable materials or avoid compromising the technical outcome of the work. C. To allow special work to take place, such as establishing inventory and balance sheet, setting deadlines, liquidating and settling accounts. D. To allow the enterprise to handle periods of extra work due to exceptional circumstances when it is unable to wait for other measures to be taken by the employer. 5. The measures for monitoring work hours, rest times, and the full working period, as well as the procedures for allowing and implementing special dispensation. 6. The region to which the special dispensations apply. Article 142, the PRACAS of the Ministry in charge of Labor will set equivalent standards for the hours of presence and the actual hours worked suitable to the profession or occupation for which the work is intermittent. Article 143, the provisions of the present section can be suspended for war or other events that threaten national security. Section 3, Night Work, Article 144, for the purposes of this law, the term night represents a period of at least 11 consecutive hours that includes the interval between 2200 hours p.m. and 5 a.m. Besides continuous work that is performed by rotating teams who sometimes work during the day and sometimes at night, the work at the enterprise can always include a portion of night work. Night work is paid at the rate set in Article 139 of this law. Section 4, Weekly Time Off, Article 145, the provisions of the present section shall apply to workers employed in enterprise of any kind as specified in Article 1 of this law. However, these provisions do not apply to rail transport workers, whose time off is covered by special provisions. Article 146, it is prohibited from using the same worker for more than 6 days per week. Article 147, weekly time off shall last for a minimum of 24 consecutive hours. All workers shall be given in principle a day off on Sunday. Article 148, when it is established that having all staff take Sunday off would be detrimental to the public or jeopardize the normal operation of the enterprise, the rest must be arranged as follows. A. Give all staff rest on a day other than Sunday. B. Rest from Sunday noon to Monday noon. C. Rest by rotating all staff. Necessary authorizations must be requested from the Ministry in charge of labor. Article 149, it is permitted by law to give the weekly time off by rotating the day off to establishments belonging to the following categories. 1. Manufacturers of foodstuffs intended for immediate consumption. 2. Hotels, restaurants, and bars. 3. Natural flower shops. 4. Hospitals, hospices, asylums, homes for retired persons. Mental institutions, dispensaries, health clinics, and pharmacies. 5. Bathhouses. 6. Publishers of newspapers, information and show business, museums and exhibitions. 7. Vehicle rental firms. 8. Enterprises supplying electricity, water and power for machinery. 9. Businesses providing land transportation other than railroads. 10. Industries using materials that rapidly deteriorate. 11. Industries where any interruption of operations could cause the product being manufactured to spoil or deteriorate. And 12. Industries performing work for safety, sanitation, or public utility. APRACA's ministerial order of the Ministry in charge of labor shall list the types of industries contained in categories 10 and 11, as well as other categories of establishments that are entitled to benefit from rotating the weekly time off. Article 150, APRACA's of the Ministry in charge of labor shall determine the methods of enforcing weekly time off in factories that operate around the clock and for specialists employed in the round-the-clock manufacturing operations. Article 151, in case of urgency that the work is immediately carried out necessarily for salvageable measures or preventing imminent accidents, or to repair damages to materials, facility installations, or buildings of the establishment. The weekly time off can be suspended for staff needed to perform the urgent work. The right to suspend this rest shall apply not only to workers of the enterprise where the urgent work is necessary, but also to another enterprise making repairs in the interests of the first enterprise. In the second typical enterprise, each worker must be given a compensatory break equal to the missed time off, in the same way as for workers in the first typical enterprise who are normally involved in maintenance and repair. The provisions of this article cannot apply to children less than 18 years of age and to women. Article 152. Guards and caretakers in industrial and commercial establishments who cannot have their time off on Sunday must have a compensatory time off on another day of the week. Article 153. In retail food stores, the weekly break can be given from Sunday afternoon to Monday afternoon or by rotating the shift for 1 day break per week. Article 154. In retail stores, the weekly break can be cancelled upon authorization from the labor inspector if it coincides with a local holiday. Each worker deprived of the weekly break must be given compensatory time off in the week that follows. Article 155. In enterprises where bad weather results in days off, these forced days off can be deducted from weekly breaks to a maximum of 2 days per month. Article 156. In seasonal industries or industries that process perishable goods or foodstuffs that are sensitive to bad weather, the weekly break can be suspended as an exception upon authorization from the labor inspector. Article 157, a Prakas of the Ministry in charge of labor shall list the particular industries that are included in the general categories laid out, stated, in Article 155 and 156 above, as well as the provisions for providing compensatory time off. Article 158, when the weekly break is given to the workers collectively, a legible notice indicating the days and hours of the time off must be posted in a conspicuous place. Article 159, when the weekly break is not given to the workers collectively, there must be a special list including the names of the workers subject to a particular rest schedule, and indicating this break scheme. Newly hired workers must be added to this list after a period of 6 days. The list must be constantly updated and must be made available to the agents in charge of labor control for approving it during their visits. Article 160, any business owner, director, or manager who wants to suspend the weekly break must request authorization from the labor inspector and, except for acts of God, must do so before the work commences. He must explain to the labor inspector about the circumstances that justify the suspension of the weekly break, indicate the date and duration of the suspension, specify the number of workers to which the suspension applies, and indicate the plan for providing compensatory time off. If the labor inspector refuses to authorize the suspension of the weekly break, he must inform the business owner, director, or manager of his refusal in writing within 4 days upon receipt of the request. Lack of notification is considered valid authorization for suspension of the weekly break.